Have you ever stopped to think about how your personal identity connects with, well, your legal identity?
It's a really fundamental connection.
Yeah, and what happens when something core, like your sex description, needs to change in the eyes of the law? How does the law even handle that?
That's a huge question.
It is. And today, we're actually going to dig into exactly that. We're doing a deep dive into a specific South African law, the Alteration of Sex Description and Sex Status Act 2003.
Act 49 of 2003, yes.
Our mission, really, is to unpack this piece of legislation, make it make sense, whether you're just curious or maybe you need this information personally, or perhaps you're studying law. We'll be looking directly at the act, its purpose, the key parts, and, what it actually means in practice. This isn't just dry legal text.
Not at all. It's about lived experience meeting the legal framework. And the fact that an act like this even exists, well, that says something significant.
What does it signal, would you say?
It signals, I think, a recognition by society, or at least the legal system, that things need to adapt. That the law has to find ways to accommodate the reality of people's identities. It gives a formal path.
A path to align legal status with lived reality.
Exactly, which is so important for dignity and just, well, being recognized.
Okay, so let's start at the beginning. What is this act, formally?
Right. The full title is the Alteration of Sex Description and Sex Status Act number 49 of 2003.
And its legal journey. When did it come into force?
Well, the English text was signed by the president. It was assented to on March 9th, 2004.
Okay.
Published shortly after, and it actually came into effect just days later on March 15th, 2004.
Wow, that was quick. Seems like there's an urgency there.
It suggests a recognized need at the time, yes.
And the act itself states its purpose pretty clearly right at the start, doesn't it?
It does. It says it's to provide for the alteration of the sex description of certain individuals in certain circumstances.
Okay, certain individuals, certain circumstances.
And to amend the Births and Deaths Registration Act, 1992, as a consequence, and to provide for matters incidental thereto.
So fundamentally, it's about creating that legal way to change the recorded sex description.
And making sure other key records, like the birth register, match up. It's consequential.
Right. Now, with any law, understanding the definitions is, well, it's crucial. Section 1, I assume.
Absolutely. Section 1 defines the key terms. Without clear definitions, the whole thing falls apart, legally speaking.
So what are the important ones we need to grasp here?
Okay, let's break a few down. First, gender characteristics. The Act defines this as the ways in which a person expresses his or her social identity as a member of a particular sex.
How they express it.
Yes, by using style of dressing, the wearing of prostheses, or other means. So it's about the social expression.
Got it. What about gender reassignment?
That's defined as a process which is undertaken for the purpose of reassigning a person's sex by changing physiological or other sexual characteristics.
A process.
And includes any part of such a process. So it can be ongoing, not just a single event.
Okay. And intersex.
The Act says, with reference to a person, means a person whose congenital sexual differentiation is atypical to whatever degree. So covering variations present from birth.
Clear. Anything else definition-wise that stands out?
Well, medical practitioner is defined quite broadly. It's not just doctors under one specific act, but covers various health professionals under different pieces of legislation.
So ensuring access to the right experts.
Precisely. And then it distinguishes between primary sexual characteristics, basically, the form of the genitalia at birth, and secondary sexual characteristics.
Which are?
Those are defined as the ones which develop throughout life and which are dependent upon the hormonal base of the individual person.
Right.
And finally, sexual characteristics is used as the sort of umbrella term covering primary, secondary, or gender characteristics.
It's quite detailed. You can see why that precision is needed, can't you?
Absolutely. When you're dealing with something so personal and legally significant, ambiguity is the enemy. These definitions create the necessary boundaries for applying the law correctly.
Okay, definitions sorted. Now let's get into the process. Section 2, right? This is how someone actually goes about applying.
Exactly. Section 2 is where the rubber meets the road, so to speak. It outlines who can apply.
And who is eligible.
There are two main groups mentioned. First, any person whose sexual characteristics have been altered by surgical or medical treatment or by evolvement through natural development resulting in gender reassignment.
Okay, so post-transition individuals, broadly speaking.
Yes, through medical, surgical, or even natural development routes. And the second group is simply any person who is intersexed.
Right. And where do they make this application? Who handles it?
The application has to be made to the Director General of the National Department of Home Affairs.
Home Affairs. Okay.
Yeah.
And what do they need to provide? What's the required paperwork? I imagine it's quite thorough.
It is, and it varies slightly depending on the applicant's situation. Everyone needs their birth certificate. That's baseline.
Makes sense.
Then, for those applying because their characteristics have been altered through treatment for gender reassignment, they need reports.
Reports
From the medical practitioners who were involved in their treatment or procedures. Or, if that's not possible, a report from a medical practitioner who has experience in that field.
Okay.
And crucially, in all cases of gender reassignment like this, they also need a second report. This one has to be from a different medical practitioner who has examined the applicant.
A second opinion, essentially, to confirm things.
You could see it that way, yes. It adds a layer of verification.
And for intersex applicants, what do they need?
For intersex individuals, they need a medical report confirming their intersex status. That's the first part.
Right.
But they also need another report, this time from a qualified psychologist or a social worker.
Okay, what does that report need to cover?
It needs to confirm that the applicant has lived stably and satisfactorily for at least 2 years, continuously, in the gender role that matches the sex description they're applying for.
So evidence of lived experience over time.
Exactly. It connects the legal change to their established life.
It's a comprehensive set of requirements. What if, after submitting all this, the Director General refuses the application? Is that the end of the road?
No, there's an appeal process built in. If the Director General refuses, they must give written reasons for that refusal.
Okay, reason are required.
Yes. And the applicant then has 14 days to appeal that decision to the Minister of Home Affairs.
The minister. And if the minister also says no?
Then there's one more step. The applicant can take the matter to the magistrate's court in their district, applying for a court order.
Ah, so it can go to court. How does that work? Is it a public hearing?
No, the Act specifies the applicant appears in chambers. That means it's a private hearing, not open court, protecting the applicant's privacy.
That seems appropriate.
The magistrate can ask for more information or proof. And importantly, the applicant can have a legal representative with them during this process.
And if the magistrate agrees with the applicant?
Then the magistrate issues an order directing the Director General to make the alteration in the birth register. The court order overrides the earlier refusal.
So there are avenues for review if things don't go smoothly initially.
Definitely.
Okay, let's assume the application is successful either straight away or after an appeal or court order. What actually happens next? What are the legal effects? Section 3 and 4, I believe?
That's right. Section 3 covers the order and its effects. Once the Director General grants the application or receives that magistrate's order, they must proceed in terms of Section 27A of the Births and Deaths Registration Act, 1992.
Okay, what does Section 27A do? That was inserted by this act, right?
Correct. This act actually amended the Births and Deaths Registration Act to include Section 27A. It basically mandates the Director General to physically alter the sex description on the person's birth register.
So the official record is changed?
Yes. The alteration is made, it gets dated, and then the person is entitled to get an amended birth certificate showing the new sex description.
That's huge. An official document reflecting the change.
Yeah.
And legally, what's their status after that date?
The act is very clear. Section 3, subsection 2, states that a person whose sex description has been altered is deemed for all purposes to be a person of the sex description so altered as from the date of the recording of such alteration.
Deemed for all purposes. That sounds comprehensive.
It is. It means legally, in all situations, marriage, contracts, records their identity is that of the altered sex description from that date forward. Full stop.
That provides significant legal certainty.
Absolutely. But there's another crucial part in Section 3, subsection 3.
Oh, what got?
It deals with existing rights and obligations. It states that any rights or obligations the person had before the alteration are not negatively affected by it.
Ah, so it protects things acquired previously, like, say, a marriage or inheritance rights.
Exactly. That's incredibly important. Think about the potential chaos otherwise. Your marriage suddenly invalid, your parental rights questioned, your professional qualifications void. This clause prevents that.
It ensures continuity and prevents the alteration from causing unforeseen legal harm in other areas of life.
Precisely. It's a vital safeguard. Without it, the process could create as many problems as it solves.
That's a really important point. And just to wrap up the specific section, the Act's short title, as we said at the start, is simply the Alteration of Sex Description and Sex Status Act, 2003.
That's the one. Section 4 just gives the short title.
So looking back at our deep dive, we've really walked through this act, its purpose, the language it uses, the practical steps for application and appeal, and the profound legal changes that result, and clearly carves out a necessary legal path for people to align their official records with who they are.
It does. And connecting it back, this isn't just about paperwork. It's fundamentally about human rights, about dignity, about being able to move through the world authentically and have that identity legally affirmed.
It shows the law trying to catch up with, or at least acknowledge, human reality.
Yes, and legislation like this really does reflect a broader societal shift, an evolving understanding of identity itself. It challenges older, more rigid legal frameworks.
Which leads to a final thought, perhaps. Thinking about this act, about how law adapts, makes you wonder, doesn't it?
How so?
Well, as our understanding of identity keeps evolving, and it surely will, what other parts of our legal systems might need to change, how can law best reflect and serve the huge diversity of human experience going forward?
That's the ongoing question, isn't it? What does an act like this tell us about where the law has been and where it might need to go next?
Something definitely worth mulling over.